Welcome back to the Emily Show for Monday, June 22nd. We have a lot to talk about, and there are going to be court hearings that are going to happen later on in the day. Remember, I do record the podcast in advance. It's the one thing where we are not live. I mean, unless you're a member, and then we are live while we're recording the podcast, but we do record in advance. There's a lot going on Monday, June 22nd, and a lot happening this week. And it's going to be a bit of a shorter week for me because I get to go see DCI kickoff this week and see Travis perform with the Cavaliers. And I'm very excited. But do you know what else I'm excited about? We have some Murdaugh coincidences that I have been waiting to talk about. So we got to talk about some Murdaugh coincidences. And Murdaugh has a court date in the murder case, finally. We have other court dates we need to talk about. David has a new court date for his preliminary hearing, and some court dates coming up in the Karen Reed cases. A lot on the criminal docket today, but a few things on the civil docket today with the Reckless Ben, Bricks and Minifigs, BAM, TRO of nightmares. And we're going to talk about that too. So, law nerds, are you ready? Let's get into it. We have a lot of court to talk about. I'm legal analyst Emily D. Baker. Yes, also a lawyer. And this is The Emily Show. I break down the pop culture, entertainment, and high-profile cases that we're all talking about. I know you want the facts, so let's get into it. Starting with the criminal docket, David was back in court in Los Angeles last week for a preliminary hearing setting in California. They do a lot of things by preliminary hearing, not by grand jury indictment. And that's that first hearing where you see witnesses testify, the defense participates, different than a grand jury, and then you get into the trial track. It is a probable cause hearing, but in that case, we know that there will not be cameras in the courtroom based not only on the allegations. Yes, it is a special circumstances murder case, but also there are allegations relating to Celeste, the victim, who was underage, and those are allegations of a sexual nature, and the court will not have cameras in the courtroom for any of this case. For that reason, the judge has already stated that. The preliminary hearing is expected to last 5 or more days, so this is going to be an extensive presentation of evidence. I expect most of it will be technical digital evidence, whose phones were doing what and when, where the car was and when, that Tesla, etc. But that has now been reset. It was supposed to start at the end of the month, but now it has been bumped to July 7th for another preliminary hearing status conference. And then it is now slated to start July 21st. However, that could still get continued. There is a lot of digital evidence in this case. I wouldn't be surprised if we see some more continuances. Special circuit cases take a minute. So when the defense came in early on in the case and was like, we're ready for this all to be out in public, they have now continued to continue the preliminary hearing, saying that they need more time. And I'm not surprised. I'm sure the prosecution is like, can we stop just setting dates that we're not going to meet? To juxtapose that just a little bit, remember the Nick Reiner preliminary hearing just got set out for a setting date in September. So we've got two different cases with defense attorneys taking kind of different angles to getting this case moving forward. But I'm going to keep an eye on that and let you know if those dates continue to change. They very well might. Law Nerd, a quick break to thank our sponsor, Lola Blankets. It is the coziest blanket in our house. I love that it is A, machine washable, B, it's got a little bit of stretch so it wraps up beautifully, and C, the quality doesn't change when you wash it. It still feels and looks like new. Lola makes the perfect gift for anyone in your life. Plus, they actually have specific Paw Nerd products now, which is absolutely incredible. But if you're looking for a gift and you're just not sure, who doesn't need a cozy blanket? And they've got so many different options. You can find one that just looks great in your home no matter what. Law Nerd, you know you don't have to take my word for it because Lola has over 20,000 5-star reviews. That's right, I said 20,000 5-star reviews. Thousands of people gifting it, loving it, and talking about it, just like me. The first Lola blanket I ever received was actually a gift, and I was absolutely obsessed. And now every member of my family has their own Lola blanket, and then the cats decide who they want to share with. There's a reason it's called the world's #1 blanket, and it's time for you to find out for yourself. Leonard, I know you're ready to check out Lola blankets, and for a limited time, you can get 40% off select Lola blanket products with code Leonard at checkout. Just head to lolablankets.com and use code Leonard. That's lolablankets.com with code Leonard. And after you check out, if they ask how you found out about them, let them know it was the Emily Show. Get ready to wrap yourself in luxury with Lola blankets. And now, let's get back to it. Continuing on in the criminal docket. Well, this one's going to be a little bit of both. We've got a little bit of criminal docket and a little, it's like Mambo number 5 and a little bit of civil docket. So in the criminal docket, Alex Murdaugh has now a judge assigned and a preliminary court date. He will be in court on June 29th, 2026. What's going to happen when Murdaugh's in court on June 29th? Well, that is the first status hearing on the murder trial. Since his case was overturned, the Supreme Court assigned it now to a judge. That judge we talked about on stream and elsewhere is going to be assigned for all purposes. So no matter where this case is heard, if it goes to trial back in Colton County or if it's moved to another county in South Carolina, that is the judge that's assigned. And that judge and the case are going to stay together throughout the course of the murder trial. So Alex Murdaugh's setting will be back in court. We know the prosecution said that they want this case to go before the end of the year. That's not going to happen. I don't see how it's possible that this case goes to trial before the end of 2026, but I'm very interested to see what happens on June 29th and when they set those dates for. So we will be talking about that once we find out what happens in that court hearing. Don't worry, I'm sat. And lest we forget that Murdaugh's also on the civil docket because Murdaugh sued Courthouse Becky. And we've got some updates on that I have been waiting to talk about. So you're not going to believe this. Murdaugh, remember, sued Courthouse Becky. Poot and everybody did a press conference. They are suing her in federal court for deprivation of rights. Different than the Karen Reed civil case for deprivation of rights. Yes, they are both 1983 claims, but claiming state actors doing things in a different way. And in the Karen Reed case, you have not only the deprivation of rights and malicious prosecution, but you have conspiracies in that as well. Murdaugh, it's just one count in the civil case, deprivation of rights by impeding with the jury. And that's what he's accusing Courthouse Becky of. Now, Courthouse Becky has filed her answer to the complaint and a motion to dismiss. And her motion to dismiss is not just a standard 12b6 failure to state a claim. She's also alleging under 12b1 that there's no subject matter jurisdiction. And there are some interesting arguments that are made. We will do a deep dive on this if you are interested. She's actually made some interesting arguments regarding the damages that Murdaugh is seeking. He's seeking $600,000 to recoup the costs of his first criminal trial, arguing that the only reason he has to go to trial again is because Courthouse Becky tampered with the jury. And if Courthouse Becky hadn't tampered with the jury, then he wouldn't be going to trial again, which is like accurate. Those are facts. But he's seeking to recoup all the cost of his legal fees for trial 1 because he's got to go to trial and trial number 2. So they're arguing in one part, well, the damages aren't under the subject matter jurisdiction because that doesn't fall under 1983. They're also arguing that really what he's seeking is damages for his attorney's costs for the second trial because he would have had to pay for lawyers in the first trial anyway. So he really wants the cost because he has to go to the second trial, and because the second trial hasn't happened yet, those are premature expenses. And so the case isn't even ripe yet for the court to consider because he would have had to pay for trial 1 anyway. So he's really seeking damages for trial 2, and that's not ripe, which is an interesting argument. And then if that wasn't enough, she's also arguing multiple types of immunity because she was an elected official and a state actor. So she is arguing the immunities that you would expect of a state actor, including, like, literally all of them. What am I saying including? All of them. She's arguing quasi-judicial immunity, qualified immunity, and others. So she is saying that even if he's suing her because she's acting in her official capacity, she's protected by qualified immunity from civil liability for civil rights violations. I'm so interested to see what happens with that. But here's the best part. We didn't even get to the best part because honestly, the audacity to say that like, oh, but I was acting in my official capacity as the clerk of court speaking with the jurors, because I can see the argument saying your job as clerk of court was to organize the jurors, but not to tamper with them. So the litigation on that is going to be really interesting. I understand why lawyers are going to put every defense out there on their motion to dismiss, but also the audacity. I'm interested to see how these arguments and more play out. Let me know if you want a deep dive on that, but here's the tea. Come here. Here's the tea. Do you remember when we covered Alex Murdaugh being sentenced in his federal criminal case? If not, we're going to revisit that for a minute. I promise it's relevant. Alex Murdaugh was sentenced after a plea in his federal financial crimes case. First, he argued that he was not properly advised by counsel and that he should be allowed to withdraw his plea. Do you remember this? And the judge is like, bro, you're also a lawyer and you also talk to your lawyers. Like, what are you talking about? And he's like, I was dealing with my addiction and I had all of these struggles and I just didn't know. That's what we're talking about first before he's sentenced and before the judge allowed the plea to go ahead. And when he was talking to the court, he said that he took responsibility for his crimes. And now we are looking at the article from that day from the state where he took responsibility, but he said that it was his heavy opiate use and his addiction was a key factor in why he was stealing from his clients. He said to the court, I want you to know, and I want the victims to know, I am filled with sorrow. I am filled with remorse. I am filled with guilt. I am very committed to trying to be a better person. They described that at times he appeared to choke on his own words and said to the judge, I know there's not enough time and I don't possess sufficient vocabulary to express to you in words the magnitude of what I feel about what I did. So this is Murdaugh speaking to the judge saying, I don't have sufficient vocabulary to tell you how sorry I am, after he tried to withdraw his plea. He also said that one of the reasons that my addiction grew to the extremes that it did is that I was using opiates to hide from the things I was doing to the people that I cared about. I hope, he said, I hope with every cell of my existence, I hope that I would not have done the things that I did had I not been addicted to opiates. First of all, let's go back and talk about the internal inconsistencies here, because he said he was using his addiction and using the opiates to hide from the things he was doing. But then he turns around and says, and I hope I wouldn't have done those things if I wasn't using opiates. It's internally inconsistent. And the judge interjected, and this is Judge, I think it's Gergel because it's Gergel, but the judge interjected as Murdaugh was giving his soliloquy and said, no truly impaired person could pull off these complex transactions, because this was all financial crimes. He said that Murdaugh used his charm and charisma to seduce a web of conspirators by the siren song of affluence. What, first of all, is siren song more commonly used parlance in South Carolina? Because this is two South Carolina judges who are influenced by one another or are just in the same book club, because we've got the siren song of fame with Courthouse Becky, and now we've got the siren song of affluence coming after Murdaugh with Judge Gergel, is what I'm going with. So then the ability to yoink the plea deals denied, and the judge goes ahead to sentence him. And look at this. The judge sentenced Murdaugh to 480 months, 40 years. The prosecution asked for 30 years. Let's take a minute to appreciate how unusual it is in a financial crimes case for a federal judge to go above and beyond, and then above and beyond by 10 years what the prosecution is asking for on sentencing. It's unusual. Financial crimes are normally undercut. To go 10 years above what the prosecution is asking for was wild to me then, wild to me now. And that's not where it stopped. Let's look at how this sentence broke down because it matters. So when the judge imposed sentence, the judge imposed 360 months for the conspiracy to commit wire fraud to run concurrently, and then 240 months for conspiracy to commit wire fraud and 3 counts of wire fraud to run concurrently to each other, but consecutive to the other sentences, and then another 120 months on each of 14 counts of money laundering. And those were running together, but then consecutive to the others. So it was a group of charges, consecutive. And that's how we get to the 40 years. But then the court ordered $8.7 million in restitution and then an additional $10 million in forfeiture. So anything that could be forfeited, any property, anything that could be forfeited, an additional $10 million. So over $18 million in restitution and forfeiture. Now, are people going to see that money? It's going to be difficult, but does it indicate how significant of a fraud the judge thought that this was? Yes. So when we are looking at the courthouse Becky of it all, the federal case just really got underway. Remember, it was just filed on May 17th, 2026. But not only did Murdaugh have a judge recently appointed in the criminal case, he had a federal judge appointed in Murdaugh sues Courthouse Becky. And guess who that judge is? Hello, Judge Gurgle. Good to see you again. So the judge that sentenced Murdaugh on the federal financial crimes case is now the judge assigned to Murdaugh versus Courthouse Becky. Oh, how interesting this is all going to be. I cannot wait to see how this all plays out in federal court in South Carolina because, well, when I was looking at the name of the judge, when I saw that a judge was assigned, I was just like, wait a second. I know that name, and I don't know very many federal judges in South Carolina. So I need to go take a look and see if I am correct. And sure enough, that in fact is the judge who sentenced Murdaugh to the 40 years. And what do we know about this judge just from what we saw in the Murdaugh financial crimes? He really doesn't seem to like folks in positions of power or in official positions getting up to fuckery. So I don't think he's going to be real happy with Courthouse Becky either. I mean, he's clearly not very happy with Alex Murdaugh, but I don't think he's going to be really happy with Courthouse Becky either. He takes people flouting the justice system pretty seriously. And Courthouse Becky is definitely in that category. So I am so curious to see what will happen. So curious to see what will happen. I'm curious to see if Courthouse Becky is going to ask or perhaps bring a motion to have it reassigned, but we will see. I don't think Murdaugh will want it reassigned because this judge has already sentenced Murdaugh. Murdaugh pled in that case. It really has nothing to do with this civil case that's going to unfold. And I think the judge will also be displeased with Courthouse Becky's behavior. So I'm curious to see if Courthouse Becky's lawyers are going to have anything to say about that. So I'm keeping an eye on that. Let me know if you want a deeper dive into what Courthouse Becky is arguing in her motion to dismiss, because there's some interesting stuff in there. But for our purposes today, the motion to dismiss has been filed. Her answer to the complaint's been filed. Murdaugh's got judges assigned in both places, and we're keeping an eye on both the state criminal case for the murder trial and the federal civil case, Murdaugh sues Courthouse Becky for fuckery. And speaking of the civil docket and fuckery, there is a continued hearing in Massachusetts, also on Monday, June 22nd in the afternoon, because the court did not complete the hearing in the Karen Reed wrongful death case regarding when Colin Albert will be compelled to appear for deposition. The court told the lawyers to all talk about it over the weekend, have a little conversation, and sort out when Colin Albert is appearing for deposition. So the court has not formally granted Karen Reed's motion to compel, but the court told Colin Albert's attorneys in that hearing, you are going to have to produce him for deposition before the August deadline for discovery So it's not going to be the fall. You need to tell me when he's appearing for deposition. We need to sort this out, get back here Monday and report back on that date. So we'll be talking about that on stream on Tuesday, I'm sure, because I'll be keeping an eye on that court hearing, and we'll see how spicy the court is when we get to hearing on Monday afternoon, because the court seems to be reining everybody in on TikTok. When's this discovery getting done? So I'll be talking about that on Tuesday a bit more. Leonard, a quick thank you to our sponsor, Hungryroot. You know that grocery shopping is one of like my ADHD most challenging tasks, and Hungryroot makes it so easy. And sometimes you want meals that you can easily prepare. Sometimes you want meals that are heat and eat, and sometimes you just need groceries. And Hungryroot has you covered for all of those things. They have over 50,000 recipes, 1,000 grocery items. You are going to find what you need, and all the food is held to incredibly high standards, so you know that you are getting organic meat and produce, and they source only high quality ingredients. So whether you're ready to skip meal planning altogether, or you just want to check out my beloved low sugar sour gummy crunchy rings, those things are so good, and I have never found them anywhere other than Hungryroot. Hungryroot truly meets you where you're at and makes life so much easier. Leonard, I know you're going to love Hungryroot as much as I do. And for a limited time, get 40% off your first order plus a free item in every order for life. Go to hungryroot.com/Leonard and use code Leonard. That's hungryroot.com/Leonard and use code Leonard at checkout to get 40% off your first order and a free item of your choice for life. Now, let's get back to today's episode. And then also coming up for both civil and criminal hearings is Reckless Ben in the Lego Bricks and Minifigs et al. Remember, Reckless Ben, and I covered this in a very long deep dive live stream when we were looking at the Bricks and Minifig corporate versus Reckless Ben civil case. I was like, this is wild in that the civil RICO is wild. The allegations there are wild. The fact that they tried to bring in the previous owners of the Bricks and Minifigs location in Oregon, that they say is kind of the stemming of where the confusion from their side over the Legos that were consigned by Brian Mansell. They're saying the previous owners were kind of part of this civil conspiracy, but then they never brought the other owners in. And I've seen lots of questions about, well, wouldn't they just be does 1 through 15 in the case? That's not a proper use of that doe placeholder. With that placeholder, it's for unknown parties. For we haven't discovered who might be involved yet. We haven't discovered who also might be working with Reckless Ben. These are unknown individuals at the time of filing. They know exactly who the former franchise owners are in Oregon. They named them throughout the complaint, but they did not sue them. So they are not or should not be does in this case because they are known. So that would be an improper joinder down the road as does. They should have just sued them when they sued everybody else. Why do I bring it up? Well, they are also bringing themselves into court in the civil case as interveners, asking to come into court and be like, hey, Your Honor, so we're not being sued here, but they've been talking about us quite a lot. So time out. We'd really love to talk to you about this temporary restraining order. And can you please let us come to civil court, be heard on this temporary restraining order that I think is hideously overbroad. I hate everything about it. But they're saying, look, this also seems to try to impact us. We are not named parties here. We are named a lot. We are named dropped parties, but not sued parties. And you've got this hideously overbroad temporary restraining order. Can you please let us intervene in this case on the question of the temporary restraining order? So you now have the Gorman parties coming in or asking to come into the Reckless Ben civil case to be heard on the temporary restraining order. And I'm glad somebody's doing it because A, they do seem to be purportedly restrained in this. B, they have another lawsuit going on with Bricks and Minifigs in Oregon. C, well, it's horribly overbroad. And D, they're coming in with their lawyer saying, can we at least argue the temporary restraining order? We are impacted by it. And in fact, you name us specifically in it, even though we're not sued parties, which is the proper purpose for an intervener to try to come into a case. They are impacted by what the court is doing. And so they are trying to say, for a limited purpose, we would like to be heard here. Otherwise, if you're not one of the parties on either side of the V, like you don't go here. You don't get to just come into court and be like, I'd like to be heard. But there are instances where interveners are allowed to come into court. We've seen this in a couple of cases. We covered intervener litigation in the Koberger case where the media entities all had one attorney who was arguing on behalf of the media coalition saying, hey, we're impacted by the court's non-dissemination order. We think it violates our rights as media. What are we doing here? And so that's really what the Gorman parties are doing here too, is arguing this side quest issue. And I think will be allowed to intervene. We'll see what the court does on the TRO, but I think they will be allowed to intervene. And so we've at least seen one party come in with lawyers and argue that the TRO is too broad. Again, we will deep dive that on stream this week a little bit more, but who we still haven't seen come to court with a lawyer to argue about the TRO is Reckless Ben. And I'm really hoping that as the week goes on, leading up to this hearing, which is going to be on June 30th, that we see Reckless Ben have an attorney come to court on his behalf. I worry that he might think that just going to court and saying, well, here's all the footage, Your Honor, is sufficient on this TRO. It's not going to be. This is something you need an attorney to argue and be prepared and argue well, because this TRO is not going to just get removed on the 30th without substantial argument. And even then, I don't know if this court will be inclined to completely remove the TRO. At least the Gormans are showing up with lawyers saying this TRO is overbroad and a problem, but Reckless Ben needs to do that as well. But I have seen him give interviews now since the TRO has been filed, saying that he thinks that this TRO is just going to be gone on the 30th. And I think that's an unrealistic expectation. And that's not the only thing he's in court in. He's also going to be appearing in court in short succession in 2 criminal cases. And I'm happy to see that at least in one of his criminal cases, he now has lawyers, but he does not have lawyers on the civil case yet, and they have not appeared. And these filings from lawyers appearing in his criminal case are from a number of days ago now. So no lawyers on the civil case yet. He has criminal lawyers on one of his criminal cases, the stalking case, and he's in court on that case on July 1st. He also has the criminal trespass case that he has a hearing for on July 6th, and lawyers have not appeared in that case yet either. So I don't know if the criminal lawyers on the criminal stalking case will then become his lawyers on the criminal trespass case, but those attorneys seem pretty specifically to be criminal attorneys, which is not what you need at all when fighting the civil case. So I wait to see if we are going to see a notice of appearance filed on the docket in the civil case, but so far that has not happened. And I worry that it might not. So I guess we will see what happens when we get to the hearing on the temporary restraining order June 30th. And for lawyers to prepare in what is kind of a complex factual issue, you need some time. And I think the issue of the TRO, I mean, the overbroadness is somewhat easy to argue because it's striking. It's breathtaking in how overbroad it is, truly. But he also has a criminal protective order that restrains him from having any interaction with Josh Johnson in the criminal case. So there's also a criminal protective order. Because that criminal protective order stands, I don't think a civil judge is going to be comfortable just saying, okay, I'll get rid of the order entirely, let the criminal order handle it. I do think a judge should constrain the boundaries of that TRO, but it's a more factually complex situation than just saying, well, I've shown all the video and so I wasn't doing the things that they said I did, so it should just be handled. That's not going to happen easily. And these are evidentiary hearings. So evidence is going to need to be presented to the court in a variety of forms before this hearing happens. So I am not optimistic that the court is just going to completely get rid of the temporary restraining order. I hope that the court will definitely limit this temporary restraining order because it is breathtakingly overbroad, but I don't think it's just going to go away on the 30th. And if things get filed late, I could very much see a situation where if oppositions to the TRO are filed late, that Bricks and Minifigs asked to put this hearing over till later in July. So I'm going to be keeping an eye on that. I'm curious to see what happens. I know you're curious to see what happens, but I have seen Reckless Ben saying things and continuing to say things like, if I talk about this case at all, I'm going to jail. That's not exactly what the TRO says at all. And that's not the first penalty that we will see. So I also hope that he has the opportunity to talk to civil counsel in this case about the boundaries of that temporary restraining order, though overbroad, and what the court might do in narrowing that down and then what will be restrained. I worry that the court doesn't quite understand the online space in saying, oh, we don't need a bond for this. Like, it's not going to impact anyone financially to say, take these videos down. I'm concerned that the court needs to be enlightened a little bit about the fact that those things can be impactful, and that information is going to be served to a judge better coming from an attorney than coming from a party. And I hope that that's what we see. But at least we do see a set of lawyers coming in with the Gormans saying, Your Honor, this TRO, seriously, what? Because it makes me so mad. We're going to talk about that TRO more this week because I'm still pissed off about it. How does this even get signed? Yep, it makes me mad. Reckless Ben back in court on June 30th in the civil case, July 1st on the criminal stalking case, July 6th on the criminal trespassing case. The Karen Reed wrongful death case, back in court first, June 22nd, but then is back in court after that on a number of dates for follow-ups. So we got Reckless Ben in court in Utah, June 30th. We got Alex Murdaugh back in case June 29th. We are going to have lots to cover. Hopefully this episode helped you stay a little bit more in the loop about everything that's going on. And I'm so curious about what's going to happen with that courthouse Becky civil case. We're going to be talking a lot of Murdaugh coming up. The Murdacity continues. And I will be back with you, not next week on the podcast, but the following week. If you want to follow along with my adventures going to see Travis performing with the Cavaliers in DCI, I will be sharing that on the app and on social media, mostly Instagram. You can find me there, the Emily D. Baker, same as everywhere. And I will be keeping you in the loop with the Cavaliers show. I'm very excited to go see him and to go see the kickoff for that. As I'm on the road a little bit this summer, we will have some scheduling changes and we will be keeping you in the loop on the Lawnerd app with those scheduling changes. Lawnerd app at lawnerd.com so that you know when we're going live. And then on the court dates when I can give you updates, even if I'm not streaming that day and covering it the next day, I update you there too. So I will keep you posted. Lawnerds, it's time to go. Thank you for being here. Thank you for being a Lawnerd. Take care of yourself, take care of each other, and I will see you in the next one. Cheers. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Lawnerd app at lawnerd.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Lawnerd.